Hello, everyone. This is Compass, navigating legal studies for your mission. This video is a legal essay practice for law students and bar exam takers. Today's topic is motion and new trial. Problem. Plaintiff was employed as a sales manager for Retail Incorporation. In her third year of employment, she filed a complaint with the Human Resources Department alleging that her supervisor made repeated derogatory comments about her ethnicity. A month later, plaintiff was terminated. Plaintiff subsequently filed a lawsuit in federal court claiming wrongful termination based on racial discrimination in violation of federal law. During voir dire, a preliminary examination of a witness or a juror by a judge or counsel. A potential juror failed to disclose that they had been dismissed from a prior job under circumstances they believed to involve racial discrimination. The juror later became the foreperson of the jury. At trial, plaintiff presented evidence, including testimony from colleagues, about the supervisor's discriminatory remarks and a performance review, indicating she met expectations before her termination. Retailing corporations countered by arguing that plaintiff was terminated for budget cuts and provided emails showing discussions of company-wide cost-saving measures. The jury found in favor of plaintiff, awarding damages for lost wages and emotional distress. After the trial, Retail Incorporation discovered the jury foreperson's undisclosed background and filed a motion for a post-judgment judgment as a matter of law, or alternatively, a new trial. Retail Incorporation argued, first, the evidence did not support the jury's verdict. Second, the jury foreperson's non-disclosure and potential bias compromised the fairness of the trial. Problem 1. Was Retail Incorporation's motion for a post-judgment judgment as matter of law procedurally proper? Second, should the trial court grant Retail Incorporation's motion for a post-judgment judgment as a matter of law? 3. Should the trial court grant Retail Incorporation's motion for a new trial based on insufficient evidence? 4. Should the trial court grant Retail Incorporation's motion for a new trial due to the jury foreperson's non-disclosure and potential bias? Number 1. The issue is whether Retail Incorporation's motion for a post-judgment judgment as matter of law was timely and raised arguments previously preserved during trial. Under Rule 50 of the Federal Rules of Civil Procedure, a motion for judgment as a matter of law must be made during the trial and may only be renewed after judgment on the same grounds raised in the initial motion. The post-judgment motion must also be filed within 28 days of the judgment. Retail Incorporation timely filed its motion within the 28-day limit. However, if Retail Incorporation failed to move for judgment as a matter of law, pre-verdict judgment as a matter of law, during trial or raised new grounds in its post-judgment motion, for example, arguments about the strength of evidence, the motion would be procedurally improper. Therefore, if retail incorporation failed to move for judgment as a matter of law during trial or introduced new grounds, its motion is procedurally improper. Number two, the issue is whether the evidence presented at trial was sufficient to support the jury's verdict. To grant judgment as matter of law, the court must find that no reasonable jury could have reached the verdict based on evidence presented, viewing it in the light most favorable to the non-moving party. Plaintiff introduced evidence of discriminatory remarks and a favorable performance review, while Retail Incorporation provided evidence of budget cuts. The jury was entitled to weigh the credibility and sufficiency of the evidence. The evidence supporting plaintiff's claims was sufficient for a reasonable jury to find in her favor. The court should not grant Retail Incorporation's motion for a post-judgment judgment as a matter of law. Number three, the issue is whether the jury verdict was against the weight of the evidence, justifying a new trial. A new trial may be granted under Rule 59 if the jury's verdict is a miscarriage of justice, but the trial judge must not simply substitute their judgment for the jury's. Plaintiff presented a credible evidence of discrimination, which the jury could reasonably accept. Although Retail Incorporation's evidence of budget cuts was persuasive, it does not appear that the verdict was a miscarriage of justice. Therefore, the court should not grant a new trial on the basis of insufficient evidence. Number four, the issue is whether the jury foreperson's failure to disclose relevant background information and potential bias compromised the fairness of the trial. A new trial may be granted if juror misconduct such as non-disclosure or bias prejudiced the fairness of the proceedings. Courts consider whether the non-disclosure was intentional and whether the undisclosed information suggests actual bias. The jury foreperson failed to disclose prior relevant experiences that could reasonably raise questions about impartialities. As the foreperson, his influence on the jury further heightens the concern. Therefore, the court should grant a new trial due to the jury foreperson's non-disclosure and apparent bias. Let's wrap up this session by revisiting the key rules. A motion for judgment as matter of law must be made during the trial and may only be renewed after judgment on the same grounds raised in the initial motion. The post-judgment motion must also be filed within 28 days of the judgment. To grant judgment as matter of law, the court must find that no reasonable jury could have reached the verdict based on the evidence presented, viewing it in the light most favorable to the non-moving party. A new trial may be granted if the jury's verdict is a miscarriage of miscarriage of justice, but the trial judge must not simply substitute their judgment for the jury's. A new trial may be granted if juror misconduct, such as non-disclosure of bias, prejudiced of fairness of the proceedings. Courts consider whether the non-disclosure was intentional and whether the undisclosed information suggests actual bias. Thank you for watching. See you in the next video. God bless you.